All right, court is calling 2024 CR 1237 and 2024 CR 1238, State versus Eric Cantu. Can I have parties announced?
Megan Galloway and Lauren Espinosa for State.
Charles Buck and Lindsay Shaw for Mr. Cantu.
And are you Mr. Cantu?
Yes.
All right. We were having a contested hearing, and the state had read into the record on the First Amendment motion to revoke community supervision in each of the cases violations of condition number 1 and 21. To those violations, Mr. Cantu pled not true. The court took testimony. Defense, the state has rested with their witnesses. Do you have any witnesses?
No, we don't, Judge. Just brief argument.
All right. So state defense, do you rest and close?
The state rest and close, Judge.
We do, Judge.
All right. So before, of course, the court makes a ruling on whether the allegations are true or not true, the court will hear argument if either party has argument.
Yes, Judge. At this time, the state is going to ask that you grant the state's motion, revoke the defendant's community supervision, and sentence him to his underlying sentence. And at this time, we'll reserve the remainder of our time for rebuttal.
All right.
Judge, on behalf of Mr. Cantu, Mr. Cantu and Lindsay and myself are certainly aware of the burden of proof that's required in a case like this. And we understand that it's a lower burden than would be in a trial per se. That being said, I think that the evidence does support certainly the violation of 21. Did he leave without permission? Yes, he did. What I want to point out to the court is the reasons that he left and the exigent circumstances that in his mind existed at that time. The testimony from the complainant was that in agreement with what Mr. Cantu believed, and his text messages show the same, that he thought she was home. And the daughter at that time was just over a year old. He called her, and as the complainant also testified, she received multiple calls from Mr. Cantu that she didn't answer, even though she wasn't home as he thought. So at this point, she also testified that she had been the victim, or she had had some incidences of harassment and stalking from other people, and she was very clear to point out these threats and stalkings were not related to Eric. And that was one of the reasons she stayed at Eric's house. That's the reason that she testified that she asked Eric's mother to assist in her getting out of that lease because of these threats from individuals other than Eric. So now you have Mr. Cantu, who on that night, knowing that there had been past threats towards her, not being able to reach her when she's home, he goes over to her house and knocks on the door. She doesn't answer. So at that point, he's able to get in through the sliding glass door and check to see if she's there. I mean, and that is consistent with a father who would be concerned for the mother of his child and his child. So while I expect that the court could certainly find it true, I would say there's an explanation at least for the court hopefully to understand why he did what he did as far as going over there without first getting the permission or getting somebody to answer the phone so he could talk to about this. Now, the burglary thing, the iPad, did he take the iPad? Yes, he did. I mean, and I think the evidence shows that the iPad, as one of the evidence from the state is the picture of the iPad at his home. So that is certainly an issue. The evidence also, I mean, I think the most concerning point about that part of the case is that the complainant testified, had it not been for Eric texting her about what he found on the iPad, she would have never called the police. You know, she didn't wait and she didn't call the police when she knew the iPad was moving. She didn't call the police when she saw Eric at his door. She went and got her food and she went to work. And it wasn't until she found out what Eric had found out on the iPad that then she decided to call the police. And then even the police in their own testimony said if it hadn't been for the fact that he was Eric Cantu, they wouldn't have written a report. And the IDR says at least because of who he is, write a report. So Eric Cantu sits before you today with the unfortunate addition that he's Eric Cantu. If he was Charles Blanco, Lindsay Shaw, Megan Galloway, or Lauren Espinosa, we wouldn't be here. But we're here because he's Eric Cantu. And I would be remiss if I didn't say that, you know, certainly the state's going to get up and argue he's had trouble on probation. He's had multiple violations. This is our third, I believe, hearing. I understand that. But everything bad that Eric Cantu has ever done started after that night that he was shot by the police department. And it's that type of, and certainly as you could imagine, he suffers from PTSD from that. He suffers tremendously from what they did to him on that night. That case is still pending somehow with the district attorney's office. He's still awaiting his day in court, and that happened many, many years ago. I'm not making excuses for him. I'm just saying there's more to Eric Cantu than just meets the eye, below the surface, if you will. But on this particular instance, with these facts, like I said, understanding the burden, I expect that the court has sufficient evidence, if you will, to find it true. I just hope that the court would, if the court cannot consider continuing him on probation, the court would consider granting him 2 years in prison as a sentence. I believe that certainly is these facts and as weak as they are, they're sufficient. But I still believe there's certainly evidence to justify why he went over there. There's certainly evidence to justify what happened. And then there's absolute evidence that if it wasn't for the fact that he was Eric Cantu, we wouldn't be here at all. So when you package all of that together, if the court does decide to send him to TDC, we'd ask you to consider a sentence of 2 years.
All right, thank you. State?
Judge, at this time, the state is asking that you grant the state's motion, find the 2 violations true against the defendant, and sentence him to his underlying sentence in TDC. And Judge, I want to echo something that the complainant, Emily Prue, testified to, and that was that this is more than the iPad, okay? And I want to address the claims from defense that the defendant was so worried about his daughter that that's the reason that he went to the location. State's Exhibit 16 through 22 completely eviscerate that defense that they're trying to allege. In these text messages, the defendant is texting the victim, Emily, what happened to us? You're breaking my heart. You're hurting me. Open the door. You thought you were slick. You're with him. You lying. You, Emily. I caught you. You better answer the phone. In all these text messages, there is not one mention of that 1-year-old daughter. And I want to point out that we're submitting to the court that he's this great father, that he had the audacity to go in there and take the iPad that his daughter uses to watch Dora the Explorer, according to the defense. I want to address the claims that Emily was not going to report this. Okay, she called the 911 3 times, and she was willing to leave work to go and report this crime that occurred against her. And I know the court is aware, that she was under subpoena, and that's the only reason that she testified in this hearing. But I want to address also some other claims that were made at the start of this hearing, which is that this is not family violence and that the state should not be going forward on it. But I would submit to the court that this is the perfect example of a family violence situation where we have a victim that doesn't want to go forward, and a reasonable deduction from the facts is the reason that she doesn't want to go forward is because the only support system that she has is that of the defendant. And that cannot be the status of justice in Bexar County, Judge. And so for those reasons, I do want to point out that this is the defendant's 3rd MTR, and the court is well aware of the history surrounding this case. So there was a first MTR, and then the second one was what it was, and then here we are. But I submit to the court that this defendant has continually thumbed his nose at the orders of this court, and he needs to be held accountable for that. And so we would ask that you find the violations true and sentence him to a prison sentence, Judge.
All right, thank you. All right, so the court, based upon the testimony, is going to find violations 1 and 21 true in both motions. I do have some questions, and hopefully parties can answer those questions for me. Number 1, defense made an argument that the defendant didn't have issues, I guess, contact with the criminal justice system until some shooting that happened. I know people assume that I watch the news a lot. I don't watch the news really. I just like to read. So my question is, prior to a shooting that you're saying he had, what was his criminal history?
Judge, if I could just have 1 minute.
Sure. And I only asked this because it was brought up.
What I was referring to was all the problems he has with this court. I want to make sure I was saying all these problems, the 3 MTRs, the evading case, that's those incidences, those appearances before this court are all after what happened to Eric.
Okay.
And that would be a correct statement, Judge.
Okay. Now, and then this shooting that occurred, does anybody know the year or the date of that?
It occurred in 2022, I believe, Judge.
2022?
Yes, Judge.
And is that a pending case?
It's pending in the 430, October 2nd, 2022. It's pending in the 437th District Court.
And this has been going on since 2022? All right. Now, my other question And I do remember the previous cases that have been brought before me regarding Mr. Cantu. I believe at the last motion to revoke he had, there were some issues brought up about mental health and that was being addressed. Does anyone know anything concerning that, counsel?
I know that we talked about it. To my knowledge, he didn't get the help he needed. But part of that, I think, is unfortunately because of the proximity and time between this and when he could have gotten the help.
And Ms. Abrams, do you know whether or not probation addressed any trauma in regards to the shooting, or whether or not that was done privately? Because I seem to recall that a previous attorney said that was being addressed privately. And I believe that was with his first attorney, maybe.
Judge, so I was not involved in the second MTR, and I was not the ADA on the first MTR.
I think it happened I think it happened at sentencing for this actual offense.
And I seem to recall regarding the first MTR that defense did put on a witness that was the defendant's therapist, that she testified in that hearing, Judge.
Judge, and he's telling me he had been seeing a psychiatrist and a therapist.
Okay.
And I can, if the court needed the doctor's names, I can provide those.
Oh, no, I seem to recall that when he was first placed on probation, there was a therapist.
I wasn't part of that, but I certainly wouldn't be surprised.
Okay. All right. Is there anything your client wishes to say or no?
No, Judge.
Okay. Probation. What is probation's recommendation?
Recommendation that's listed on the court summary was to alter and amend for local ISF followed by ISP for the duration of the probation term, Judge.
Okay. And the court will note that the court previously has alternate amended for
Yes, Judge.
ISF.
Yes, Judge. That's what I wanted to add. Thank you.
All right. If there's nothing further, the court is prepared to make its ruling.
There's nothing further from the state.
Nothing from the defense, Judge.
All right. So, Mr. Cantu, this is what I'm going to tell you. The fact that probation is saying they do not recommend revocation and they want your conditions to be alternate amended to include ISF, the court has previously done that. So I don't think it's appropriate to do it again. The court is going to grant the motion revoke, and I'm taking into consideration everything that has been presented to the court. The court is going to sentence you to 2 years in the prison, give you credit for any time served, and this is under cause number 2024 CR 1237. This will run concurrent with 2024 CR 1238. There is to be no contact with the complainant. And at his parents' home, are there minors in that home?
No.
All right. There's to be no residing.
But his child.
His child lives in the home with the parents?
The mother of the child lives in his, the young lady that testified lives in his home.
All right. There's to be no unsupervised contact with minors. So you'll have to have supervision.
And Judge, the court brought up that he had been to the ISF facility. Will the court grant him, since he successfully completed that, will the court grant him that credit?
All right. Legally, I must do that. So he'll receive credit for any time served for successful completion.
Thank you, Judge.
Of inpatient treatment. And then next we'll move on to 2024 CR 1238. In that cause number, as previously stated, the court is finding violation of conditions 1 and 21 true. The court is going to revoke, sentence you to 2 years in the prison. This will run concurrently with 2024 CR 1237. I'm going to request the therapeutic community, the mental health unit. There's to be no contact with the complainant in the burglary. There's to be no unsupervised contact with minors. And you'll receive credit for any time served in successful completion of any inpatient treatment. In each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, but you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. You understand? All right, we can go off the record. Here's the thing. Whatever issues you have that cause you not to be successful, you're going to have to address that. If you don't address that, what's going to end up happening is you're going to continue to potentially have contact with the legal system. You understand? So if you need to seek more therapy, then you need to do that, because otherwise you're going to keep coming back and forth. You understand? All right. Good luck to you.
Thank you, Judge.
You're welcome.